Welcome to this deep dive into the Manual of Patent Examining Procedure, or MPEP. Think of this as your shortcut, really, to understand the core principles of U.S. patent law, section by section.
A very useful shortcut, I hope.
Definitely. Today, we're zeroing in on Chapter 2100 and specifically Section 2165.
That's right, the best mode requirement.
It sounds kind of simple, but I get the feeling it carries, well, significant weight for patentability under 35 U.S.C. Section 112.
It absolutely does, This requirement is really all about transparency. It's one of the basic disclosure obligations inventors have.
Okay.
And before we really dig in, just a quick thank you to Mike Shepard. His vision and hard work made this whole MPEP series happen.
Absolutely. Couldn't agree more. Okay, so best mode. What exactly are we talking about here?
Well, at its core, the best mode requirement, you find it in 35 U.S.C. Section 112A, both pre- and post-AIA versions demands that inventors disclose the best way they personally know to carry out their invention.
Okay, the best way they know.
Right. At the time they file their patent application, the key thing here is stopping inventors from getting those exclusive patent rights while, secretly keeping their favorite way of doing it under wraps.
So you can't patent the idea but hide the best recipe.
That's a good way to put it. The court case in Re Nelson really drove this point home.
So it's not just describing a way it works. You have to share the best way you knew right then. How do examiners, or maybe courts later, figure out if this has actually been done?
Yeah, that's where this two-pronged test comes into play. It's a two-part analysis.
Okay.
First, there's the subjective prong. Did the inventor, in their own mind, actually have a preferred way, a best mode, of practicing the invention when they filed?
So what they were thinking.
Exactly. What did they personally believe was best? Second, the objective prong. If they did have a preferred method, was it disclosed in the application clearly enough?
Clearly enough for whom?
Clearly enough that someone skilled in the relevant art, another expert in that field, could actually take that disclosure and replicate the best mode.
Interesting. So it's both what the inventor knew and whether they wrote it down well enough for someone else in the know to use it. What about, say, an inventor knows a really clever software routine makes their gadget work way better, but they only describe a more basic one?
That is a perfect example, really, of where you might run into a best mode violation. If that significantly better routine was known when they filed, and they didn't put it in the disclosure, that could definitely be seen as holding back the best way.
Okay. Now, I bet there are some gray areas here. Are there subtleties we should be aware of?
Oh, absolutely. It's not always black and white. One key point came out of the Ernsthausen v. Nakayama case. It said the patent application doesn't have to explicitly point and say, this specific example is the best mode.
Oh, okay.
As long as the description of that best mode is somewhere in the application, just included in the text, that's usually enough. No big flashing sign required.
That's helpful. What if the inventor provides some detail, but maybe not a super exhaustive step-by-step walkthrough of the best mode? Is that automatically a fail?
Not necessarily, no. There's another case in Reg A that basically said not having a hyper-detailed example isn't in itself a failure to disclose best mode.
Right.
It depends on the context. How well understood is the technology already? Sometimes a more general description might be perfectly sufficient for someone skilled in the art to understand and practice that best mode.
So it's really about enabling peers, other experts in the field, just not necessarily writing an instruction manual for a total beginner.
Precisely. The best mode can sometimes be described using ranges like temperature ranges or categories or even just general preferences. It doesn't always have to be an exact minute recipe.
Got it. Now, the America Invents Act, the AIA, it always seems to come up in these patent discussions. How did the AIA affect this best mode requirement?
Right. The AIA definitely made a mark here. It created a pretty significant shift, but mainly in the consequences of failing to disclose the best mode.
Okay, consequences how?
Well, the duty to disclose it during patent examination, when you're trying to get the patent from the USPTO, that's still there. But, and this is the big change, failure to disclose the best mode is no longer an independent reason to invalidate an already granted patent during infringement litigation.
Okay. So let me see if I get this straight. Examiners still check for it when reviewing the application.
Yes, they do.
But if a patent gets granted, someone suing for infringement can't just point to a lack of best mode disclosure as the sole reason to kill the patent in court.
That's basically it. Examiners still review under the relevant Section 112 standard, whether it's pre-AIA or post-AIA, depending on the filing date. It's still a requirement for getting the patent. The AIA just changed its power as a defense after the patent issues.
That's a really important distinction. Okay, now this obligation to disclose the best mode, does it cover every single tiny detail mentioned anywhere in the patent application?
No, and Section 2165 is clear on this. The best mode requirement applies only to the claimed subject matter.
The claims.
Right, the specific things the inventor is actually seeking legal protection for in the claims section of the patent. There's a case, Northern Telecom v. Samsung, that's often cited for this.
So if I invent a new kind of toaster, and I mention in the description that it looks really cool with a particular, maybe proprietary chrome finish, but I only claim the toasting mechanism itself.
Right.
I don't necessarily need to disclose the absolute best way to achieve that chrome finish.
Generally, no, assuming that finish isn't essential to how the claimed toasting mechanism works. If it's just an unclaimed feature, the best mode for that specific feature isn't usually required. The focus is on enabling the claimed invention.
That makes sense. Protects what's legally claimed. What about timing? Say an inventor files a patent application, and then maybe a year later, while working on improvements, they discover an even better way to make the invention work. If they file, say, a continuation application based on the first one, do they have to update the disclosure to include this newly discovered, even better mode?
Generally, no, they don't. The rule is tied to the filing date of the application that establishes the right. If you file a continuation or claim priority to an earlier application, you aren't obligated to update the best mode based on things you learned after that original filing date.
Okay.
The inventor's knowledge is assessed as of that critical filing date. It's like a snapshot in time.
Right. The snapshot is the filing date. That avoids penalizing inventors for ongoing R&D. Now, what kind of things would get an inventor into trouble with best mode during examination? What constitutes a violation?
The main issue is omissions that amount to concealment. And this doesn't necessarily mean they intended to hide something maliciously, though it could. It's about failing to disclose something crucial to practicing the best mode they knew. For example, there was a case, Spectre Physics v. Coherent, involving a specific proprietary brazing method that was key to making the device work optimally. Not disclosing it was a problem.
Because it was essential.
Yes. Or another one, Danacore v. IPC, where an essential undisclosed surface treatment for a seal was at issue. If you leave out a piece of the puzzle that's necessary to achieve that best result you knew about, that can be concealment and a best mode violation.
It sounds like it's about holding back something that someone skilled in the art would really need to replicate the invention properly in its best known form. But earlier, you mentioned it's actually quite hard for examiners to issue a best mode rejection during the initial examination. Why is that?
That's right. The bar is pretty high during what's called ex parte prosecution, just the applicant and the examiner. Examiners need actual evidence.
Evidence of what?
Evidence that the inventor, one, knew of a better mode than what they disclosed, and two, that the disclosure was inadequate to enable that mode. Proving what the inventor actually knew at the time of filing based just on the application itself is, well, difficult.
Yeah, I can see that. Mind reading isn't part of the job description.
Exactly. So this kind of smoking gun evidence, it doesn't usually just fall into the examiner's lap.
So where does it typically show up then, if not during the initial review?
It's much more common for this kind of evidence to come out later. Often during litigation, when the other side can conduct discovery, depose the inventors, look at internal documents.
Discovery.
Right. Or sometimes in post-grant proceedings at the patent office, like inter partes review, where there's an adversarial process and more opportunity to dig into the facts.
So it sounds like the initial exam focuses more on ensuring some enabling mode is disclosed, and the fight over whether it was truly the best mode often happens later, if at all.
That's a pretty good summary, yes. So, wrapping up Section 2165, the main takeaway is that these best mode disclosures need to genuinely reflect what the inventor knew was the best way to carry out their invention when they filed.
Right. Be honest about your preferred method.
Exactly. And provide a fair description that allows the public, or at least those skilled in the art, to understand and use that preferred way.
And even though the AIA changed how failures are treated in court battles,
Correct.
the requirement itself remains a core part of the examination process at the USPTO. It's fundamental to that patent bargain. You get your exclusive rights, but you have to fully teach the public about your invention, including the best way you know how.
Precisely. It ensures that when the patent eventually expires, the public gets the full benefit, including the most effective implementation known at the time of filing.
This has been really clarifying. Section 2165 definitely drives home that, well, honesty and completeness in the patent application aren't just ideals, they're actual legal requirements.
Absolutely. Full and truthful disclosure is really foundational to the whole patent system.
So for anyone involved in the patent process, remember this best mode element. It's about sharing not just the what of your invention, but the how specifically, the best how you know.
A crucial point to keep in mind. And with that, thank you for joining us for this exploration of Section 2165 in Chapter 2100.
Just a quick disclaimer before we go. This summary was generated with the help of AI tools and is for educational purposes only. It might have errors, and it's definitely not legal advice. Always consult the official MPEP or a qualified patent professional for authoritative guidance.
Very important reminder.
Absolutely. Stay tuned as we continue our journey through the MPEP section by section. Until next time.